Okay, I'm going to call this special council meeting to order. It is December 14th, 2023. We'll go ahead and do a roll call.
Mayor Wusso,
Present.
Mayor Pro Tem Dame,
Here.
Councilor Schachter,
Here.
Councilor Kaup,
Here.
Councilor Weimer,
Here.
Councilor Zelinski, and Councilor Godis. We have a quorum.
Thank you. We're going to go ahead and move on to the second and only real item on this agenda, and that is the update on case number 23CV030160 involving the August 10th executive session, the Open Records Act, and the Open Meetings Law.
Thank you, Madam Mayor. Loud. I'm going to turn this over. Obviously, we got an order of the court a day ago. Finding the city in violation of the open law for the executive session on August 10th. There are a couple of decisions based on that you need to make regarding moving forward. Had a couple of provisions, a couple of opportunities. I'm going to ask Richard Peterson Kremer and Shoshana Rosenthal, who are partners in my law firm and handled that litigation, to address those. We're probably going to need 2 or 3 motions out of you today, just to be clear on the record as to how you're proceeding.
Good afternoon, Madam Mayor and councilors. As Carl mentioned, Judge Meyer with the District Court for Garfield County issued an order yesterday evening finding the city violated the Open Meetings Law at its August 10th executive session. This followed on a kind of preliminary ruling that we informed you of following a November 30th to December 1st hearing where Mayor Wusso, Mayor Pro Tem Dem, City Clerk Brian Hughes, and former City Manager Beverly Marshall all testified. At the conclusion of that hearing, Judge Meyer concluded that there's a reasonable belief that Open Meetings Law had been violated because Dr. Marshall had not been provided any real choice and had been effectively terminated in the executive session. And then furthermore, that the later meeting didn't, on the 17th, accept the resignation, didn't cure any violations that might have happened. So the order yesterday really just kind of confirmed her analysis that she made in that bench ruling on December 1st. In the intervening time, there was some adverse case law that came from the Colorado Court of Appeals, the newspaper, the Sentinel, to the city of Aurora about direction that had been given in the executive session to first end an investigation, and then secondly, to come back open session with a stipulation and proposal to pay the other party's attorney's fees. At the district court level, the city of Aurora prevailed in that case, but then the paper appealed and won at the Court of Appeals, and they said that a straw poll cannot occur in executive sessions. That is new intervening case law that probably it is cited in the judge's order in this case. It also undermined precedent that municipal attorneys have long relied on, that a later action in open session that is in furtherance of any direction given in the executive session could be ratified in that open session, and that would cure any potential Open Meetings Law violation. That Aurora case also pretty much overturned that precedent. So it has left a lot of municipal attorneys around the state kind of scratching our heads, wondering how we do executive sessions, but that's I think a conversation for a different time. We have two discrete items that we need some direction on moving forward in this litigation. At the end of the order, Judge Meyer set potential briefing schedule for it would be an application under subsection 6A of section 204 of the Colorado Open Records Act, and that would be for us to argue that releasing the recording would do substantial interest to the public interest. We've looked at the case law. There's not many cases where anyone succeeded in this. I talked a couple of times with a colleague at the law firm, Nathan Dunn and Mayer, who has tried several of these cases. Nick Poppy is his name. He said he made 10 of these applications and failed all 10 times, and the judge will not redact that information short of it being the location of the clearances. So not something we are recommending moving forward with. The second issue that we need some direction on is whether to appeal this decision. Before the Aurora case came out, I think we would have said this was a good case to appeal. We worked very hard to establish a good factual record, getting evidence into the record that would be helpful in having it overturned on appeal. The intervening case law with Aurora is not helpful. You know, the whole straw poll concept is, I think, a little amorphous. Whether that happened in the executive session, I think, is in the eye of the beholder. In any case, consensus was reached, and that's kind of the issue going forward under Aurora is, can you reach consensus in executive sessions? And so we also spoke with Nick about the potential of appeal, and his gut was less than 50% chance of success on appeal. Pre-Aurora, he would have given it higher than 50%. So, and that would incur additional attorney's fees, you know, for the city to lose on appeal, additional attorney's fees for the city and for the other party. You know, we have an order. If we don't pursue the additional briefing, the record will be released on Tuesday, unredacted. If we do pursue that additional briefing, our brief would be due on Monday, and then the opposing party's brief would be due on the 27th, which I think is a Wednesday. And then the recording wouldn't be released until after the judge made a ruling, if she, you know, ruled it to be fully redacted or partially redacted. Oh, sorry. So, you know, the recording does contain some attorney-client privilege material that we don't love having out there in the open. Since Dr. Marshall signed a full waiver and release upon severance, we don't have the sense that advice could be used adversely to the city. So, yeah, I think that's where we are. Happy to answer questions.
I would like, just for clarity, when Richard spoke of the briefing on redacting, it is a very high standard to redact information in the public interest, is what he was speaking to, and that would go to names, say, of staff that were used within confines of that. We view it as highly unlikely that the judge would, in fact, redact that information on the basis, you know, that it's uncomfortable for those people's names to be out in the public. So I just wanted to be clear on that unfortunately, it's a very low likelihood to be successful.
But certainly up to us whether or not we would like you to approach that and continue to make an attempt.
Absolutely. It's your call on if you want us to brief that. We just feel like, given the case law, we would, if you direct us to do it, we will do our very best to be successful at that. I just think that there might be, we have to be honest about the chances of success.
Okay, bring it back to council for questions. Counselor Godus. Hold on. Yeah, I know it's not. Yeah.
Problems on Tuesday night.
Yeah, I don't have my normal, let's see. I don't have my normal light ups.
You can hear it, right?
No, because Shelley cannot. Shelley, Counselor Kalp has kind of indicated that she's already struggling a little bit with hearing people. So let's do this.
This is unfortunate because we did a sound test prior to the meeting and it was working.
Yeah, Ryan, you see if you can help me
Yeah.
out with the control now.
Yeah,
I can't remember what we did on Tuesday.
Yeah. Yeah, look. Great, there's no option. Yeah, there's no option.
There we are.
Okay.
Have a green light. Shelley, can you hear me?
Yeah,
Okay, got affirmative from Shelley. Carl, Richard, would you say, so it appears that we had an open meeting or a executive session under case law interpretation that when, at the time we had it, was considered legal and consistent with case law. It also seems that had this Aurora decision that came down on December 7th, had that come down on December 17th, we'd be still operating under the legal interpretation of which we entered that executive session a month ago. I guess my question would be, it's a little Monday morning quarterbacking at this point, but would if that case law had not come out in intervening week, would your recommendation potentially be that we would have stronger grounds for appeal?
Yeah, I think absolutely. And I will say that, the legal advice that I gave to you guys on the 10th, leading into that meeting, I believe at the time was solid based on case law and practice in the state of Colorado. Obviously, it is a shifting area of the law, and I will just note that I was on a call with CML attorneys, we meet on a semi-regular basis, and it was the number of cases in this arena right now. There are probably 5 or 6 that are either at the trial level or going up on appeal right now on similar issues. It's a place that we're really struggling to find where the judiciary thinks the lines are for us. So absolutely, it would have changed, I think, the advice we were giving today on whether to appeal or not. And certainly had that decision come out on August, 5th, as opposed to December 7th, it would have changed the advice I gave you going into that.
Thank you.
Counselor Dame.
Thank you. Richard, what are the efforts or what would the production be to try to redact those names?
In terms of briefing.
Yeah, in terms of you guys' effort to actually go forward and file the paperwork
Yeah.
and do all that, just
You have thought much about that. I guess would be probably another 10 plus hours of research, listening again to the executive session, and figuring out where those specific places are in the recording that would warrant the action.
so about 10 hours of effort, roughly. 10 to 15.
Yes,
Okay.
yeah.
Thank you.
Counselor Schachter.
Just clarifying what Counselor Dame said, we're talking about the possibility of redacting certain staff names, particularly from the
And community member
Yeah,
names, and anyone.
anybody
mentioned
that
besides us.
named.
Yeah, exactly.
And I hear the odds are slim, given what we know. And are we, what's the degree of certainty that we immunized ourselves from any action from the former manager?
We would be releasing this under court order. And so it's not an option for us. We also have a waiver and release that she voluntarily signed and significant consideration for that. So from that standpoint, I think the city is complying with the court order if they release, and also took the necessary steps ahead of that to protect itself.
Thank you.
And to confirm, I was not present with Dr. Marshall's testimony. She asked that the tape not be released. Is that correct?
That was her opinion when,
Mhm. Mhm.
if she'd like to see the recording released, she said no,
Mhm.
she doesn't know what's it.
Yeah. And as we move forward, that we at this point, could we release the tape to the community on our own discretion prior to the date?
So
You absolutely could.
Mhm.
It doesn't change. The judge will release it or not release it on Tuesday regardless.
Sure.
And it if we don't brief it, or
Mhm.
if we brief it and she declines to redact any of it, released in whole.
Mhm. Counselor Godus.
So in 7 years of being on council, I've never had an open session where I've spoken with our attorneys about legal strategy.
Sure.
Is this, the fact that we're here on the dais asking our council sensitive questions about legal strategy, is that a byproduct of the December 7th Aurora decision?
I think that we are being very conservative after that because
Mhm.
we are all struggling. Municipal attorneys across the state are struggling with how you receive direction without forming a consensus
Mhm.
in an executive session.
Thank
Do you anticipate, this doesn't reach too far out of here, but do you anticipate looking into this as municipal attorneys at the state level?
I believe that there are discussions either way.
Mhm.
The Aurora case could still be appealed to the Supreme Court,
Mhm.
which may be wiser. And, there are many things that could happen, but at this point, this is the ultra conservative
Mhm.
approach to this.
There
Okay.
is another case on appeal right now that Nick Poppy is also handling from Del Norte on
Mhm.
very similar issues to what we faced. That is sort of, I guess, ahead of us in the pipeline. If we feel that that case would be heard and decided ahead of ours. But I can tell you, I think it's finally rising to the point where CML is willing to maybe go to the legislature and ask for some clarity there, because this approach, this ad hoc approach in court of trying to figure out what we can and can't do is both expensive and, it's horrible for you guys to go through, it's horrible for our communities to go through, trying to figure out what the judiciary feels is the right guardrails. And so I'm hopeful that the legislature would stop, because it's becoming definitely a significant issue for a number.
Knowing, and this is not an attempt to put you on the spot, Carl, but knowing that we gave you or asked for your help in protecting Dr. Marshall's reputation, moving forward with a change, if you could go back in time, knowing what you know now, with those same buffers, what would that look like?
I think what I would tell you, knowing what I know now, with the Aurora case
Yeah.
out there, I would tell you that I would not recommend an executive session
Mhm.
on any matter which you could feel compelled to give direction on.
Mhm.
And so in Dr. Marshall's case, I would have told you that that entire discussion would needed to have taken place on the dais,
Mhm.
and that you would have needed to give direction from the dais regarding her status. And I think what is very difficult for me, having walked through that with a number of managers over the years, is that is a brutal way to deal with an employee.
Mhm.
And I may well have tried to find a way to still not have that happen, because I think that is just, like I said, a brutal way to deal with a manager.
Mhm.
And it certainly makes a difficult job that much harder.
Mhm.
But the state of the law is, I would tell you today, if I knew then what I know today in terms of the Aurora case, I would tell you have to do it out in the open. As painful as that is for you and for that manager and for staff and for our community, that's where it would have to take place. And so what that does take away is something that many of you may have experienced in your employment careers, which is when things just aren't working out, it's nicer to exit with a resignation and an understanding and moving on
Mhm.
than, a public termination. And I think these cases have removed that room from your relationship with your manager.
It definitely creates such a challenge for us, because I think we all walked into the executive session with a high degree of respect for Dr. Marshall. And then even, subsequent meetings with her recognized that she had a skill set that it didn't align with our community, her management style. And yet here we are now, and knowing the damage that we can do to her reputation with the release of this tape, that was our intent all along. And I think that's what's so hard in this situation. So we do have other counselors. Counselor Schechter.
So in the name of public legal guidance, I'd like the two of you to help us understand what would happen should we appeal? And if I heard you correctly, there's two or three similar cases ahead of us. In that process, and of course we have to weigh some dollars, should one of them succeed in their appeal? I know you can't be that specific because you can't tell what the court's ruling is specifically, but what does that then do to our odds of appeal, or our do we need to continue appeal regardless? Do we know, or does that unravel what this
I
decision
mean, on
is?
this case specifically, if you would need to appeal to prevent the release. If one of those cases ahead, either the Aurora case goes to the state Supreme Court and we get some more specific guidance, or maybe the Del Norte case helps out on that appeal, and maybe we get a little bit different guidance, we might see a different outcome at front of the panel that we might be assigned on appeal. You know, I think it is we're in a particular moment where, because the guidance is unclear, I'd say the odds are slightly better for us, but I would never say they were great on going up on appeal on being successful. You would have to see it through to the end. The risk there is attorney's fees for plaintiffs in this case, which that's a component of this order, the outgrowth of that, of finding the violation, as well as, so if we lose on appeal, they've incurred more fees, you've incurred more fees. You know, it's you guys' call, but there are
just
costs
wanted to
and risk
hear.
associated. I'm not going to come anywhere close to trying to predict an outcome right now in this area of the law.
Okay, thank you.
And Nick did mention this today because he had fully briefed the Del Norte case when the Aurora case came out. He's like, I guess I just have to argue this oral argument now. I can't do any more written briefing on this. So that's probably happen.
That's all I am right now. Thank you.
Okay. Counselor Godus.
Is it okay if I make a comment?
Yeah.
Okay. This is really troubling because when we entered that executive session, we did so under the law as it was written and as it was interpreted at the time, and we did so lawfully. The interpretation of the law changed on us, and that's really unfortunate. And I've seen and heard from people that are delighting in the fact that we got our hand caught in the cookie jar, trying to be non-transparent or trying to hide something. And man, that glee that we got caught, man, I just want to tell you, all the gadflies out there that are delight in that is really, really troubling, because this session where we're asking our attorneys sensitive information and going, gosh, what should we do? And debating among ourselves, that answer you just gave about, well, okay, here's what it'll look like. Here's what we were responsible for, these fees and that fees. And these are, $10, $20, $30,000. If we take this court and a case and it goes all the way to the state Supreme Court, it could be $30,000, $40,000 potentially. So these are big decisions, and that $30,000, $40,000 doesn't just come from nowhere. It comes from other operating budgets, police, fire, rec center. When we go into executive session and talk about a real estate transaction, and one of us says, well, no, you know what? I have experience in this and I don't think this. And another person says, well, I have experience in the financing side and I think this. Or we sit and look around and go, man, it seems like we should do this. We cannot do that anymore. And guess who gets to hear that conversation? The seller. And so if we want a critical piece of property for a park, a fire station, something, that seller now all of a sudden just knows exactly where we're at. And guess who that's going to cost? All the people of this community, all the people that live in this community, that depend on the services, depends on us running an efficient government. That comes from them, and all the people who are delighting in the fact that now everything has to be transparent. So when it comes to real estate transactions, legal advice, dealing with, Carl's going to have his annual review coming up here pretty quick. Steve Boyd, our brand new city manager, believe it or not, his 6-month review is coming in like 120 days. I can't sit down and say, Steve, man, you're doing great. I love you, man. But here's something I would love for you to work on, because I'm not going to do that in public. So guess what Steve's not going to do? He's not going to hear that from this council, and he's going to continue on. And we're going to have a less potentially a less effective council, a less effective city manager. And I think that is incredibly troubling. And as it relates to this case, I mean, this is broad implications. These are broad comments that I'm saying right now. But I think as it relates to what's in front of us in the agenda item tonight, we could not have foreseen this, because the law and its interpretation was not this when we did it. It's like going onto a football field and in the third quarter, all of a sudden the referees throw a flag and now they're like, give us round balls and a basketball hoop and say the game's changed. And so it is what it is. Life's not fair. But this whole transparency thing is going to hurt our community. And I think when we release the tape, or it is released for us, however we decide that plays out, I hope the community looks at that and again, doesn't delight in the minor details, but looks at the overall good faith effort to do the best for this community. That's what I hope. I don't have much faith in some members of our community, but I hope the larger community sees the effort that we've made to try to protect our staff and our community.
Council Weimer.
Carl, a question for you about the release that Dr. Marshall signed. Do you feel it to be airtight?
I mean, anybody can potentially file a lawsuit. I think it is about as tight as it can possibly be. It was full waiver and release of all claims. There was significant consideration given for that, and any release, which is why I would probably lean towards, if you're going to release, I would just allow the court to release, is done under court order. And so we, you as council, we as the city, took every step we possibly could, including incurring costs, defending this suit. You could have done the easy thing and been like, oh, fine, it's an ex-employee, and put the tape out there. You took, every reasonable step to protect that confidentiality. And so I don't see any real risk to the city.
Okay. Councilor Zelinski.
So yeah, I would like to make a comment too. I feel like this is more damaging to continue to dance around the issue at this point. Similar to Councilor Godes's comments. I've reflected on this a lot. I have a lot of experience with personnel matters and staffing and employees. I don't have a lot of experience doing that for a whole community. I've only done that for my own business, but I take it really, really seriously when you have to have a change in employment. And I don't know that the actions that we took on that day are significant enough to cause all of this. And I feel like we have created a lot of turmoil and mistrust in the job that we are here doing, based on the fact that this is all under a veil right now. And I think it would make me a lot more comfortable if that could just come out to light, so that the community could review what was done, what was said, and how it was handled, and recognize that this was a lot of energy and expense and time and anxiety spent for, something that was pretty run of the mill. This was an employment issue. This was handled with respect and intention and in good faith, not taken lightly, and not meant to damage anyone's reputation or potential for future employment. And it's unfortunate that we find ourselves in this position, but we do. And I have learned a ton in observing this process. And I don't think this is the death of executive session. I read through a bunch of stuff to learn what that means and what Colorado Sunshine laws are. And I think there's not a lot of trust in government as an institution at every single level. Where I think it bears the most weight is at the local level because we know each other by first name. We see each other at the grocery store, in the community, at sporting events. And if you can't trust the people sitting up here, that's where really we need to re-examine what we're doing. And so the fact that this is casting such a cloud over the actions that we've taken, I think it's time for us to just let that come to light.
Counselor Dim.
I think Counselor
Oh.
Kalp.
Oh,
Oh,
thank you.
Shelley first.
Okay, yeah, we will go ahead and let Shelley speak. Thank you, Richard.
Thank you. I will echo some of Counselor Zelinski's and Counselors Godis's comments. I do think that it's unfortunate that we find ourselves in this situation. I think everyone on council as well as staff that was guiding us and our attorney council were acting in the best interests of the city overall and the community. So I would like to say one thing about transparency though. You know, my experience with this council is that we work diligently to be transparent on all issues and follow the law. And in this particular case, we intended to follow the sunshine laws, but keep a very sensitive issue as discreet as possible. If we stepped over the line, my wish going forward is that we do work with CML as Attorney Hanlon has mentioned, and that we find out where that new line is or where that line is exactly, and we'll be guided by that going forward. But in the experience in the last several years that we've been on council, I think it's less than a handful of times that we've even had executive sessions. We avoid them at all costs, unless an issue is particularly sensitive and or a property acquisition, that type of thing, where it is in the public benefit to be more discreet about it. But in this case, I agree with Counselor Zelinski. I do not feel it serves any public good for us to continue to put more money at this or fight this. And if this is what the court has ruled, I think we abide by that. And going forward, do the best we can to continue to serve our community.
Counselor Dim.
Thank you. I don't really have anything different to add. I agree with everything I heard. I concur. Thanks, Shelley. Also, the only thing I guess is, and I want to voice my support of what Councilor Zelinski said, that I think it's time. We don't appeal, we don't file a brief, and we just move forward and let the chips fall where they may. I personally think we did nothing wrong, like Councilor Godis pointed out so nicely. We tried to protect, as they say, the innocent, and it has taken a turn. The game has changed, and I'm not sure I agree with that, but that's not my decision. That's the judge's decision. So that said, I would be in support if anybody else is as well, or council is, to talk about the moving forward.
So why don't we, they asked us for two
Correct.
directions. So why don't we just make motions and make it nice and tidy? If I heard you say you do not want to appeal, so do you want to make a motion and move that forward? Okay, and then we'll open it to conversation on that.
I was prepared to, but knock yourself.
Okay. Okay, Councilor Dim.
All right, Madam Mayor, if I may, in case number 23 CV 030160, involving the August 10th executive session, I would move that we do not appeal Judge Meyer's decision from yesterday.
Second.
Okay, we'll go ahead and call that question. Counselor Kalp, would you just raise your hand if you were a yes? And if, thank you. Okay, great. Thank you. For the record, Counselor Kalp is a yes on that. Okay.
It's unanimous, 7-0.
Thank you. Okay, now we'll give you some direction on that second one, and that would be whether or not we want to request a redaction of the record prior to its release. I'll go ahead and have Counselor Day.
Thank you, Madam Mayor. I just have a quick comment. I think just for our sake, or at least for my sake, I think we should at least try it.
Yeah, me too.
Because I think it's the right thing to do to
Mhm.
keep this as confidential as we possibly could. Again, to protect the innocent. I'm not sure it's gonna fly, but I think just so we tried everything
Yeah.
we could like we did on August 10th.
Is that a motion? The
No,
most
that's
casual
just
motion in the world?
leaving it
Okay,
out there because
okay.
Maybe there's more discussion.
Okay. Any additional question or comments, discussion, motion regarding okay, Counselor Schachter.
Well, I wrestle with, can I understand our obligation here on the dais to protect everybody we can? I would like to ask the attorneys again. If I heard you correctly, it's a very low probability that we'd succeed or a moderate. How would you classify that, please?
It's a pretty low
Okay.
probability. That was our sense reviewing the case law and then speaking about it. So
And, you know, I don't want to be contrary to Counselor Dame or anybody, but based on that information and a fiduciary responsibility as well as a responsibility of the employees, I would probably not favor moving forward with redaction and any more publicity that this thing
Mhm.
involves.
Counselor, oh, I thought I saw your like,
You did.
okay. Counselor Weimer.
Yeah, that's where I'm at, Sumner. And I just feel like, you know, for the people out there delighting in this,
Mhm.
right? And, you know, there's a headline or a talking, you know, point that we're trying to redact things
Mhm.
to protect people. Oh, protect yourselves. No, protect, you know, try to do the right
Mhm.
thing. Oh,
Mhm.
yeah, protect yourselves. Man, I see that getting turned
Mhm.
and
Like
we're at,
everything.
you know, and, you know, another, you know, call it 20 grand, 25 grand of effort to try to do
Mhm.
this when, you know, the likelihood is, you know, and I try to go back and, you know, play that tape in my head and,
Mm.
you know, when we talk about city employees, we just talk about them not vibing with Dr. Marshall,
Mhm.
right?
Mhm.
And we didn't say, you know, Joe Smith is, you know, how he can be when, you know, he doesn't like to be micromanaged. We don't say,
Sure.
we don't
No.
say stuff like that.
We don't.
And we just say that, you know, Joe and Bob and Mary don't like Dr. Marshall. That's kind of,
Yeah.
that's kind of what we said, right? And I think I'm leaning toward us just, you know, let that tape get released by the court. It'll stand on its own merit, quite frankly. I don't want any more allusions
Mhm.
to us trying to redact things and protect ourselves. Which those illusions will happen.
Counselor Zelinski.
I echo with what Council Weimer just said. I think that at this point, you know, at the risk of further disparaging our reputation and standing in the community, any pursuing of redaction is going to just do that. Would we have been a little more discreet with naming certain people in the community?
Mhm.
We absolutely
Yeah.
would have. We, again, acted in a professional manner. However, we didn't know that we were going to be on the public record in that moment. And so that's an unfortunate consequence. And so I guess this stands as my kind of statement in advance of, if you said we were likely to be able to get those redactions, I would be in support of pursuing it. But with it, the understanding that it's not likely we would be successful, I don't think that I don't see the value in it. And I think it would only do more harm.
Mhm.
But I kind of am making a statement saying, hey, if we had known, we would have been more conscious of some of the individuals that we named, and, you know, you can't unring a bell, so here we sit.
Counselor Schachter.
No, if I may say one more thing that's been echoed about transparency. In many ways, and I think it's been echoed a little, this will inhibit transparency. There's a difference between transparency. Let everybody see everything that transpires, fine. But the flip side is that level of transparency in some of these extremely sensitive and historically private matters will inhibit thoroughness, examination, and some of our required responsibilities, because information will not be discussed that otherwise would have in a manner that's suitable for governance. And so there, I think to use transparency as a blanket term and saying, hey, we're all better off, I think we have a case here where we're likely not to be. That's all. Thank you.
For me, this is the true rock and a hard place situation. Oh, I'm gonna have Shelley jump in before I make any comments. Go ahead, Shelley.
Oh, thank you. I
Mhm.
just wanted to add, I agree with the majority, but I'm hearing here on council with Schechter, Weimer, and Zielinski. I do feel like this is an important issue. We handled it as best we could. If we did overstep a line, it sounds like that's the ruling in the open meetings law. I'd like to do our best to learn where that line is, how we need to proceed in the future and going forward. But I'm not interested in spending any more of the public's money on this. And I do feel like we have important work to do on community issues that we work to solve and to better the future of our city. And it's time to, move forward from this and use it as a learning experience.
Counselor Godus.
And I think there's two issues that are, I'm very glad I let Shelley go first. So I could see that I wouldn't have to be the deciding vote because I'm very on the fence. I think, the fiscal, just on its face, the fiscal ramifications of pursuing this, that has a very low probability is not in the best interest of the city's fiscal health. I'd be willing to do that if we had a decent chance, even a snowball's chance of, we keep saying protecting the innocent, but let's talk about what that really means for just 1 second. What it means is when somebody comes and says, hey, in this executive session, I haven't listened to it. I don't recall the details. I'm sure someone said to me, several people said to me, hey, Counselor Godus, you might not know this, but this happened. And when I say that in executive session, I think all of us probably said something similar to that. That person, whether it's staff or a community member, the next time there's an issue in the community, and they might want to pull one of us aside and be like, hey, Counselor Aaron, we have Counselor Zielinski. This thing happened. It was bad. If they know that in a couple months that's going to be broadcast everywhere, be reported, and somebody's going to listen to that tape, I would hope, as an aside, I would hope that the press doesn't name names. I would plead to the press and the established journalism that they don't name names. I have no doubt that, again, the people who delight in dysfunction and chaos and seeing a government be brought to heel, I have no doubt they will listen with intent and they will put stuff on social media and write letters to editor and name names. I have no doubt they will do that. But that's going to make less efficient government because there was no chance that the people who were brave, because it takes bravery, right? It takes a certain amount of bravery to come to a person in power and say, this is not good because of repercussions that could happen. That won't happen anymore, guys. So like community, we lost. We lost today, not just today. This process, the Roar decision, causes the community to lose because there's going to be less willingness for people to step up. And so I guess my plea is that as the community, as the press, as other people are talking about this, when this tape is released, and I'm very torn, so I'd probably vote for what I've heard sounds like the majority. Just that people are responsible and thoughtful and kind about allowing those names to be brought out, because it's going to be nothing other than salacious gossip. And I think, and I hope that we're better than that.
Still on the rock and the hard place. This is really, really hard. This is one of the hardest things that I've done since I've been on council. It was really hard to make, just to hear the feedback from the community members who will be brought up. And in advance, I'm really sorry. I would have never, ever repeated anything had I known that this would be pursued and that we would end up in the situation that we're in. And I would go back in time and I would still take steps to have Dr. Marshall leave, because it was not, her management style was not in alignment with this town. And you'll hear that when the tape is released. And it's not because she was a bad person, she's lovely, but truly we had to make a decision for this community. And we know this community. All 7 of us know this community and we care deeply, or we wouldn't keep showing up, especially when it's been so hard. And so I commend you all, and I'm sorry. And if we could go back in time, I would still take steps that led to the same outcome, but the process would look significantly different if I had any control over it. And so with that, we will go ahead and I'm hearing maybe a motion formulating regarding a initial or this request to reject. Counselor Schechter, you're next.
Well, I will make a motion. I would just say, I'm glad to be with a compassionate set of peers, and maybe I'm not less compassionate, but I'm a little less concerned. I think maybe we are reacting out of compassion even greater. It has a big impact on CML and attorneys and law. And I think anybody we would talk to would say, oh, you're reviewing an employee and you're likely to terminate them. Shouldn't be done in public. So I am sorry that this has unfolded like this, but I am not sorry for the manner, the way we proceeded. And I think we will move on. And I believe we will move on with the trust of the community.
I hope so.
And along those lines, I will move that we do not move forward with any redaction.
Okay. Counselor Dim.
And I would second that.
Okay. We'll go ahead and call that question. And
what shadow?
you're an up on that? Okay.
Yep, hands up.
I was the only one then. Okay.
Can you show the board?
Yeah. And then Counselor Kaup is a yes on this motion.
Okay.
Yes, Counselor Zelinski. No, Mayor Wusso. Yes, Counselor Godis. Yes, Mayor Pro Tem Dem. Yes, Counselor Weimer. Yes, Counselor Schechter. Yes, Counselor Kaup. It passes 6-1.
Counselor Schechter.
Well, I'll make another motion and we'll open up discussion. I would also move that we do not release the tape ourselves, that we follow the court order, let the judge decide what to do.
Great, I'll second that. Sorry, Jonathan. Okay. Do you want to call the question on that, please? Okay, thank you. Counselor Kaup, if you're an up on, okay, thank you. So looks like it was unanimous.
Motion passes. It's unanimous.
Okay, before we adjourn this meeting, I did prepare a statement to be released to the press and also just the community in general. It's in front of you guys. It's been here for a little while this evening, so I don't know if you've all had a chance to read it. Are you all comfortable with the content of this letter? Okay, so I am going to read it into the public record, or to the record, and then we'll also share it. We have some journalists in the room. Thank you, Andrea, for being here. So I'll go ahead and read that now. This is a statement from the Glenwood Springs City Council. Dear Glenwood residents, we are now able to comment on the recent court case related to the executive session in which we discussed our former city manager's future. On December 13th, the Honorable Judge Meyer ruled that we violated Colorado open meetings law when we gathered consensus as to how we wanted to proceed with Dr. Marshall's employment. While it was never our intention to violate the open records or the open meetings law, we respect Judge Meyer's decision. Personnel matters are some of the most sensitive and difficult issues in any organization. Per the law, we offered Dr. Marshall the option of a public meeting or executive session when we decided to address issues related to her tenure. She opted for an executive session. We took that opportunity to act while protecting everyone from potentially harmful details. Based on legal guidance, we felt that we were operating within the law. Judge Meyer has now disagreed. The City Council has clearly stated its goals to increase trust and transparency. It is regretful that we find ourselves in this current position and hope that this note sheds a bit of light on the situation. We apologize for this breach of open meetings law. We acted and will continue to act in what we believe is the community's best interest. We have learned from this ordeal and will approach future executive sessions with even more care and caution. And we thank you. Counselor Godus.
Well said, Madam Mayor. And with that, I'll move to adjourn.
Counselor Tim.
Second.
Okay, all those in favor?
Aye.
Any opposed? We are now adjourning the special meeting. Thanks all for attending.